Okay, welcome everybody to the Roger S. Aaron Lecture. Before introducing Jeffrey Rosen, our speaker, I'm going to tell you a little bit about the Aaron Lecture and about Roger Aaron himself. I'll start with that latter thing. Roger S. Aaron graduated from Dartmouth College in 1964 and earned a master's in business administration at Dartmouth's Tuck School of Business. And after attending Yale Law School, he joined the law firm of Skadden, Arps, Slate, Meagher, and Flom. A longtime partner at that firm, he headed the firm's corporate practice and built it up into one of the industry's top merger practices. His client list included General Motors, Pfizer, and Time Warner. Mr. Aaron cemented a reputation as a trusted advisor to blue-chip companies and served as a counselor to corporate boards on a wide variety of issues. An innovator, Mr. Aaron helped create a device called the tracking stock, now a part of established corporate practice. The endowment that funds this lecture was established in his honor in 1996 from gifts from the Dartmouth Lawyers Association. The Aaron Fund falls under the larger Daniel Webster Fund umbrella and supports lectures, speakers, panel discussions, and conferences consistent with the purposes of the Daniel Webster Fund. The Daniel Webster Fund supports the study of the role of law and justice, ethics, and public policy in the lives of individuals and society as part of the liberal arts curriculum of Dartmouth College. This lecture is co-sponsored by the Dartmouth Lawyers Association and the Dartmouth Legal Studies Faculty Group. We'd also like to extend a thank you to the Lawyers Association for supporting this lecture and to welcome Bill Kennedy, the class of 1971, who's here today. Bill was a past president of the Dartmouth Lawyers Association and is on its current board of directors. Like Professor Rosen, Mr. Kennedy has connections to Georgetown University Law School. Now I'll tell you a little bit about our speaker today. So Jeffrey Rosen is president and CEO of the National Constitution Center, the only institution in America chartered by Congress to disseminate information about the United States Constitution on a nonpartisan basis. Rosen is also professor of the George Washington University Law School, as well as a contributing editor for The Atlantic. He's a non-resident senior fellow at the Brookings Institution, where he explores issues involving the future of technology and the Constitution. Since 2000, he served as a moderator for the Aspen Institute, where he conducts seminars and panels on technology and the Constitution, privacy, and free speech and democracy. He's a highly regarded journalist whose essays and commentaries have appeared in the New York Times Magazine, on NPR, and in The New Yorker, where he was a staff writer. He's also the author of several books, 6 by my current count, including The Supreme Court, The Personalities and Rivalries That Defined America. And his 6th and new book is called Louis D. Brandeis, American Prophet, and that is coming out, is that next month or next? June 1st. Rosen is a graduate of Harvard College, of Oxford University, where he was a Marshall Scholar, and of Yale Law School. And today he's going to talk about why Brandeis matters and what he can teach us about current questions involving the Constitution, monopoly, corporate and federal power, technology, privacy, and free speech. The title of his talk is The Future of Privacy, Free Speech, and the Curse of Bigness, What Louis Brandeis Means Today. So join me in welcoming Dr. or Mr. Jeffrey Rosen.
Thank you so much. Thank you so much, Adina. It is such an honor to be here at this spectacular institution. So Dartmouth has such a distinguished constitutional heritage. I always think of Daniel Webster arguing the Dartmouth College case, leading to the immortal dictum of Chief Justice Marshall about how much people love this place. And every time I come here, I am impressed by the passion and studiousness and hunger for constitutional knowledge of all of you. I'm so honored to be able to talk to you today about my favorite subject, Louis Brandeis, and what he can teach us today. This is an extraordinarily apt time to be thinking about the legacy of Justice Brandeis. The book comes out on June 1st, which is the 100th anniversary of Brandeis's confirmation hearing. He was nominated on January 28th, 1916. So there were 125 days between his nomination and confirmation. in the election year of 1916, which until now represented the longest wait between nomination and confirmation in American history. As Adina said, I have the privilege of serving as head of the National Constitution Center, which is scrupulously nonpartisan. We bring together liberals and conservatives and everyone in between to debate not political issues, but constitutional issues, so people can make up their own minds. And I'm so excited in the course of this talk to be able to show you this phenomenal new interactive constitution that we've launched that brings together the best liberal and conservative scholars in America to write about every clause of the Constitution, discussing what they agree and disagree about. This is so important in these polarized times. The College Board has made this the centerpiece of the new AP curriculum, or a centerpiece, and I'm hoping that you here at Dartmouth will take up the mantle and help us bring it to every high school student and college student in America. And we can use it to try to channel Justice Brandeis as well. So what I'd like to do is first tell you a little bit about Brandeis and why I think he is the most important constitutional philosopher of the 20th century, the one who can teach us more about the curse of bigness in business and government and privacy and free speech than any other thinker. And then we'll try to channel him on some contemporary questions involving privacy and free speech with the help of the interactive Constitution, and then we'll have a great, or what I hope will be, I know I'll learn a lot from the Q&A. Okay, so I'm just going to start with giving you a sense of Brandeis and why he matters, and this is a sneak preview from the new book, which doesn't come out until January 1st, so please don't share the video if it's circulated. But I try to argue in this book that Brandeis was the most important critic of bigness since Thomas Jefferson, essentially. He self-consciously identified with Jefferson. He was the people's lawyer who predicted the crash of '29 and would have predicted the crash of 2007. He really can teach us more than any other thinker about how to think about privacy and free speech in the age of Google and Facebook. He served on the court from 1916 to 1939, and he was the leader of a Jeffersonian tradition that is as distinctive in the 21st century as it was during the New Deal era. Namely, he was a progressive champion of federalism and small business. At the same time, he embodied a bipartisan constitutional tradition that once again is getting broad adherence on both sides of the political spectrum, from the Tea Party libertarians to progressive civil libertarians. He was, in other words, a defender of personal and economic liberty and a foe of centralization in business and government. Small government and small business fulfilled his Jeffersonian belief that small-scale communities were most likely to satisfy human needs and to allow citizens to develop their faculties. That was a phrase that he took from Jefferson and used frequently. Their faculties of reason through the rigorous self-education that Brandeis believed was necessary for full participation in American democracy. So at a time of intense polarization between conservatives and libertarians who prefer small government and free enterprise, and liberals and progressives who advocate a more energetic social welfare state, Brandeis is the historical figure who represents and blends the ideals of both sides in this crucial debate. He endorsed the Jeffersonian ideal of small business and local democracy, but he applied those ideals to uphold state regulations that tamed the excesses of big business and monopoly, and he offers, I think, a unifying vision of liberty for our fractious and divided age. Like Jefferson, Brandeis believed that the greatest threat to our constitutional liberties was an uneducated citizenry, and that democracy could not survive both ignorant and free. And because of Brandeis's pragmatic sense of human limitations, he believed that only in small-scale businesses and communities could individuals master the facts that were necessary for personal and political self-government. For this reason, as a Supreme Court justice, he generally championed judicial deference to state legislation, except when it clashed with freedoms explicitly enumerated in the First and 14th and 4th Amendments. In those cases, he became the most prescient defender of civil liberties of the 20th century. It's important to put this in the context of a broad clash about what America's constitutional philosophy should be. Both Jefferson and Brandeis viewed American history as a battle between forces of consolidation and decentralization, between agrarian producers and monopolistic financiers. In responding to the proposed Constitution, Jefferson expected that America would be divided into self-governing agricultural units of the smallest scale possible. Brandeis, too, insisted that decentralization in government and economics was the only way to protect the liberty of farmers, industrial workers, and small producers. Brandeis, unlike Jefferson, was not a strict constructionist, but he was sympathetic to Jefferson's views on political economy, and he developed Jefferson's distinction between merchant bankers, who lent their own capital for productive enterprises, and monopolists who underwrote risky instruments with what Brandeis unforgettably called other people's money. The monopolies of Brandeis's day were not government-chartered banks like the Bank of the United States, which inflamed Jefferson and Madison, but the web of private investment banks and railroads, controlled by Brandeis's nemesis, J.P. Morgan. In Other People's Money, Brandeis denounced Morgan for his oligarchic control over the quick capital of others that allowed him to control webs of influence and allowed him to make reckless bets on complicated instruments whose value he and his colleagues couldn't possibly understand. Brandeis believed that only small-scale enterprises could be mastered, and in this sense, his opposition to bigness in business and government was connected to his pragmatic understanding of the limitations of human knowledge. So I want you to have a sense of this clash between Jefferson, who actually proposed an amendment to the Constitution that would have limited monopolies only to intellectual property and only for limited terms, and Hamilton, who embraced a far broader central government. And this populist agrarian tradition that began with Jefferson, was worked out by Jackson, came to a flower with Brandeis, and then culminated in the Second New Deal of Franklin Roosevelt, which explicitly embraced Brandeis as a model, has deep roots in American history. It's interesting, too, at this moment in the presidential campaign, we're seeing opposition to the banks and the curse of bigness, both from Bernie Sanders on the left to Tea Party people on the right who denounce the idea of too big to fail and call for freedom to fail. It was distressing to see Representative Sanders, though, or rather Senator Sanders, invoke Theodore Roosevelt as the model for his plan to break up the banks. In fact, it was Brandeis and Wilson during the election of 1916 who wanted to break up the banks. Theodore Roosevelt's new nationalism wanted banks that could be regulated by strong oversight bodies, and Taft, the third candidate, wanted to prosecute the banks through vigorous antitrust prosecution. So Sanders really is the heir to Brandeis and Wilson, not to Theodore Roosevelt, and that clash is still being played out today. Okay, now let's try to channel Brandeis on free speech and privacy. Brandeis's mature views about free speech appear in his concurring opinion in Whitney versus California. That came down in 1927. It's the greatest and most beautiful defense of free speech in the 20th century. And please read it. Give yourself the pleasure of reading the concurrence if you haven't yet. In Whitney, Brandeis cited Jefferson's first inaugural for the dangers of both religious intolerance and political intolerance. Brandeis then connects the protection of rights with the importance of reasoned deliberation, counter-speech, and self-education as he channels Jefferson in Whitney. And here are his beautiful words. And just listen to the rhythm of these sentences as they build up to a kind of constitutional poetry. Brandeis says, "Those who won our independence believed that the final end of the state was to make men free to develop their faculties," there's that phrase again, "and that in its government the deliberative forces should prevail over the arbitrary. They believed liberty to be the secret of happiness and courage to be the secret of liberty." He's quoting directly there from Pericles' funeral oration. "They believe that freedom to think as you will and to speak as you think are means indispensable to the discovery and spread of political truth, that without free speech in assembly, discussion would be futile, that with them, discussion affords ordinarily adequate protection against the dissemination of noxious doctrine, that the greatest menace to freedom is an inert people, that public discussion is a political duty, and that this should be a fundamental principle of the American government." What an idealistic vision of free speech this is, unlike the cynical Oliver Wendell Holmes, who also supported an unregulated marketplace of ideas, but only because he thought that the strong should be able to crush the weak through law or else open violence would result. Brandeis, the Jeffersonian, the Periclean, believes that given time enough for reasoned deliberation, truth can actually prevail. And that's why he comes up with the most important principle of free speech in American jurisprudence, which is that you can only ban speech when it's intended to and likely to incite imminent violence. Under those circumstances, no time for reasoned deliberation and speech can be banned to prevent violence. But short of that, Brandeis says, the best remedy for evil counsels is good ones. He supports counter-speech, not suppression, because of this idealistic Jeffersonian view. Let's read a little bit more of Brandeis and get it. This is another passage, but it gives us a sense of where he got that test about that the violence has to be imminent. And what's so interesting is he's referring explicitly to Jefferson and his fellow icons of the American revolutions, not as founders, but as revolutionaries. He's talking about not the founders of 1787, Jefferson was in Paris during the Constitutional Convention, but the revolutionaries of 1776. And this is what Brandeis says. Those who won our independence by revolution were not cowards. They did not fear political change. They did not exalt order at the cost of liberty. To courageous, self-reliant men, with confidence in the power of free and fearless reasoning applied through the processes of popular government, no danger flowing from speech can be deemed clear and present unless the incident of the evil apprehended is so imminent that it may befall before there is an opportunity for full discussion. If there be time to expose through discussion the falsehoods and fallacies, to avert the evil by the processes of education, the remedy to be applied is more speech, not enforced silence. Only an emergency can justify repression. Such must be the rule if authority is to be reconciled with freedom. Such, in my opinion, is the command of the Constitution. Wow, that is just great writing. It is simple and direct. Holmes was more celebrated in his day as a stylist, but he preferred showy philosophical abstractions and fancy aphorisms. Brandeis is communicating directly with the reader in his prose and in his politics. He is a Democrat. And Brandeis shows here that his faith in deliberation is based on his conviction that if people are given time and opportunity to engage in public discussion, the power of reason will prevail. And this is intensely Jeffersonian. There's no greater statement of faith in the value of America in the value of counter-speech as the best response to hate speech, more speech, not enforced silence, the ability of the processes of education to expose falsehood as long as there's time for full discussion, and the power of courageous, self-reliant citizens to govern themselves and develop their faculties by applying free and fearless reasoning through the processes of popular government. It's the perfect expression of Brandeis's Jeffersonian creed. Note, though, that this is not a passive notion of democracy. Brandeis thinks that citizens have not only the right, but the duty to educate themselves about liberty and the Constitution. And like Jefferson, he believes that unless people exercise that duty, then the constitutional liberties will languish. And that's why Brandeis devotes his mature energies to supporting the University of Kentucky, a local university, because of his insistence on small-scale communities. And Jefferson puts on his tombstone his three greatest accomplishments: author of the Declaration of the Virginia Statute for Religious Freedom and founder of the University of Virginia. For them, education and the Constitution are very closely connected. Now let's talk about Brandeis's view about privacy, and then we'll channel him on modern subjects. So Brandeis wrote the most famous article on the right to privacy in 1890, and essentially he's concerned about a new technology, the tabloid press and the instant camera, that's spreading gossip about aristocratic celebrities like his law partner, Samuel Warren, who's concerned that Warren's domestic privacy is being invaded by the Boston tabloids. So Brandeis and Warren look at American law, and they find that American law, unlike European law, has no remedy for offenses against honor or dignity. So they go on to propose such a remedy. And in this famous article, they say that when people's dignity is affronted by tabloid gossip that used to be whispered in the closets and is now shouted from the rooftops, people should ordinarily have the opportunity to sue, unless the speech is necessary for public discourse. There's only one problem with this right. It clashes very squarely with the First Amendment's protection for free speech. If you have the right to object to truthful but embarrassing information about you, that's published in the tabloids, that's not at all consistent with the idea that the best remedy for evil counsels is good ones. So Brandeis comes to have second thoughts about his youthful article on the right to privacy. A few months after writing it, he tells his wife, rereading it, it's not as good as I thought it was. And then he becomes increasingly interested in the importance of transparency. Sunlight is the best disinfectant, he says. Transparency, the best electric light. And he begins to rethink the balance between privacy and free speech, and his mature reflections on the proper balance appear in the greatest opinion on privacy in the 20th century, and that's his dissenting opinion in Olmsted versus United States. Olmsted is decided in 1928, the year after Whitney. Brandeis is on fire, and it's a very Jeffersonian period for him. And the case involves the problem of electronic searches. So here's essentially what's going on in Olmsted. The government is wiretapping this guy who they think is a bootlegger. Booze is illegal, it's prohibition. And they walk up to the sidewalk with wires that are leading up to his office and put taps on the wires on the sidewalk outside his office. And they listen in on his phone conversation, and they conclude that he's a wild bootlegger. He's making huge amounts of money, very successfully. And they indict him and convict him. He objects that the search of his telephone conversations is unconstitutional because there was no warrant. And in a rather wooden majority opinion written by Chief Justice Taft, the majority of the court rejects his claim because they say there's no physical trespass. At the time of the framing, says Chief Justice Taft, the king's agents had to break into people's houses in order to search through their desk drawers and look for evidence of seditious libel. Therefore, the law of trespass defines unreasonable searches, and here they were on public sidewalks, no trespass, no violation. In this visionary dissenting opinion, Brandeis objects. And first, he's imagining new technologies that may transform the ability to search and seize. He has in his clipping file in the court a new article about a new technology called television, which has just been invented. And Brandeis misunderstands television. He thinks it's a two-way communication where people can see each other. Basically, he anticipates Skype. And his law clerk, Henry Friendly, persuades him to take the reference out because Brandeis hasn't quite got the technology right. But Brandeis has this amazing passage where he goes even beyond television and really anticipates, although he can't imagine it directly, not only Skype, but the age of cyberspace. Listen to this incredible passage, which again is worth reading. He says, discovery and invention have made it possible for the government, by means more effective than stretching upon the rack, to obtain disclosure in court of what is whispered in the closet. Moreover, in application of the Constitution, our contemplation cannot be only of what has been, but what may be. The progress of science in furnishing the government with means of espionage is not likely to stop with wiretapping. Listen to this. Ways may someday be developed by which it is possible, by which the government, without removing papers from secret drawers, can reproduce them in court, and by which it will be enabled to expose to a jury the most intimate occurrences of the home, anticipating the internet. Advances in the psychic and related sciences, Adina, this is your fMRI machines, may bring means of exploring unexpressed beliefs, thoughts, and emotions. Quote, that places the liberty of every man in the hands of every petty officer, was said by James Otis, of much lesser intrusions than these. To Lord Camden, a far slighter intrusion seemed subversive of all the comforts of society. Can it be that the Constitution affords no protection against such invasions of individual security? This is a staggering example, both in constitutional prophecy and constitutional translation. By invoking Lord Camden and James Otis, Brandeis is telling the story of the paradigm cases that sparked the American Revolution. James Otis in 1763 gives a speech in Boston denouncing the writs of assistance that allow the king's agents to break into people's houses and rummage through their desk drawers to see if they're violating the hated tax laws that led to the Boston Tea Party. And the writs of assistance, the general warrants, which were like the writs of assistance, authorized King George's agents in Britain to rummage through the houses of innocent suspected critics of the king to try to identify the author of an anonymous pamphlet called North Britain 45, which had accused the king's mother of having an affair with a foreign secretary, Lord Bute. So the king is not amused. He arms his henchmen with this general warrant. They break through lots of people's drawers. They read their private papers. Finally, they identify Wilkes as the author of this anonymous pamphlet. And he's tried for seditious libel. Seditious libel means criticizing the king. In a seditious libel case, truth is no defense. And in fact, according to the British law at the time, the greater the truth, the worse the offense. So Wilkes can't claim truth, but he says that the general warrant itself is an unreasonable and unconstitutional violation of the common law rights of English men and women, men at the time, because it doesn't particularly specify the place to be searched or the things to be seized, and exposes the most intimate occurrences of his mind to petty officials. And in this landmark verdict, he wins £1,000, which is a kind of McDonald's coffee-like verdict for its day. And this case is so galvanizing to the framers that people name towns and countries from John Wilkes Booth to Wilkes Barre, Pennsylvania. After the Wilkes case, they have parties where they drink 45 steins of beer to commemorate North Britain 45. This is, I don't know what the latest example is. It's the OJ case of its time. That's a long time ago. It's interesting how fractured our celebrity trials have been, that now we're more focused on presidential politics than scandal. But anyway, this is the case that sparks the American Revolution. And Brandeis says, let's be pragmatic about this and ask, wiretapping today invades even more privacy than the general warrants that sparked the American Revolution, because it can invade the privacy of people at both ends of the wires. Because a far smaller invasion was unconstitutional at the time of the framing, he says, unregulated surveillance that can reveal a great deal of personal information in the course of fishing expeditions for guilty information are unreasonable and unconstitutional, even with a warrant. And that's the power of this incredible dissent. So that's his dissenting opinion in the Olmsted case. Years later, in 1967, the court seems to adopt a version of Brandeis's test, but it does so in a way that undermines his central insight. In the Katz case in 1967, the court says, it's true that the Constitution protects people and not places, and therefore even invasions without physical trespass may violate the Fourth Amendment. But the test, the court announced, was circular. It said the question is, do people have a reasonable expectation of privacy that society is prepared, a subjective expectation of privacy that society is prepared to accept as reasonable. The problem is, as ubiquitous surveillance technology becomes commonplace, it lowers our expectation of privacy in a way that lowers constitutional protection. Justice Sonia Sotomayor objected to this state of affairs in her important concurring opinion in a case involving GPS searches, where she said, we need a new way of thinking about the Fourth Amendment, because now that the court has held that if I store my private papers on a third-party server in the digital cloud owned by Google or Yahoo, I abandon all expectation of privacy in it, then effectively we have no privacy now that our private papers are stored on these third-party servers. So Justice Sotomayor called for the court to reconceive the Fourth Amendment. She didn't explicitly invoke Brandeis, but what I want to do with you is channel Brandeis and ask the question, WWBD, what would Brandeis do? This is always the central question I ask whenever I have a hard constitutional question. And I want to ask, what would Brandeis do on the great questions that are facing us today, ranging from the Apple subpoenas to, we can talk about NSA surveillance, or maybe even ubiquitous drone surveillance that flies in the air, and then free speech questions, including what to do in a world where Google and Facebook and Twitter have more power over free speech than any king, president, or Supreme Court justice. So let's channel Brandeis on Apple. And Apple is a hard question, and largely it's a statutory question. So there's a law called the All Writs Act from 1789 that basically says that courts can issue orders to fulfill their responsibilities and can require parties to obey those orders. So the question is, can Apple be faced with an order to create a backdoor to its encryption technology under this All Writs Act because there's a valid warrant for the data of the suspected San Bernardino terrorist suspect? So like most hard questions, there are good arguments on both sides. There's one relevant Supreme Court case involving telephone tapping from the 1970s. There the court said that AT&T did have to install a pen register on its wires, but there were a pen register records all outgoing phone numbers, But there were two qualifications. One, Congress had seemingly blessed the pen registers. And second, the court said things might be different if there was an undue burden on the phone companies. Here, you could argue it the other way. Congress has explicitly rejected the idea of backdoor encryption in the 1990s when it debated the question extensively. And it's arguably a huge burden on Apple, which would have to create a new technology which would undermine the central promise it's made to its customers, which is that their data will be encrypted and secure from government search. Let's now look at the interactive Constitution to see what lessons we can glean from that. So I'm so excited to show this to you. We're going to start back historically and look at the meaning of the Fourth Amendment to the framers. And this is called Writing Rights. And we look at the Fourth Amendment, and here on the left you see all of the Revolutionary era state constitutions that James Madison basically cut and pasted from when he wrote the Fourth Amendment. None of the provisions in the Bill of Rights were written from scratch. Madison has beside him all of the state constitutions, and he's cutting and pasting among them. So one of the closest analogs for the eventual Fourth Amendment was the Massachusetts Constitution of 1780. Every subject has the right to be secure from all unreasonable searches and seizures of his persons, his houses, his papers, and his possessions. All warrants, therefore, are contrary to this right, if the cause or foundation of them be not previously supported by oath or affirmation, if the order to a civil officer be not accompanied with a special designation of the person or object of the search, arrest, or seizure, and no warrant ought to be issued but in cases and with the formalities prescribed by law. You see, 53% of the text matches the ultimate Fourth Amendment. But here, warrants are not friends of privacy. They're enemies. They immunize the king's agents from liability for trespass, and therefore they have to be closely circumspect and particularly specify the place to be searched and the person or thing to be seized. And many of the state constitutions have similar versions, and you can scroll among them and see what they say. Then we can go to the present and look to what the top liberal and conservative scholars nominated by the Federalist Society and the American Constitution Society have said about this issue. So this is so exciting. The Federalist Society and the Constitution Society, the leading liberal and conservative lawyers organizations in the country, have nominated Orrin Kerr and Barry Friedman, a liberal and a conservative scholar, to write a common statement about what the consensus history of the Fourth Amendment is. So you can be confident that every word in this common statement is accepted by both sides, because like a Supreme Court unanimous opinion, they both had to agree about every word. And appropriately, Kerr and Friedman tell the story of the case of Wilkes and Wood, which I told to you. They say the primary concern of the generation that ratified the Fourth Amendment were the general warrants and writs of assistance. They quote Wilkes and Wood, which you can read and should. And then you can learn about how the writs of assistance were used. You can hear about James Otis's speech challenging them, which Brandeis quoted in his Olmsted opinion. And then they also appropriately quote Brandeis himself by saying that if the government becomes the lawbreaker, it breeds contempt for the law. They do say that it's a hard question today about what is a search if people are in public and are surveilled without physical trespass by flying drones, for example, that can track our movements 24/7. So imagine the government announces tomorrow that it's going to track all of us for our safety and plants a drone over someone, and it focuses on an individual, say me, and follows me from door to door 24/7 for a month. Would this be a violation of the Fourth Amendment, which prohibits unreasonable searches and seizures of our persons and electronic effects? It's sort of similar to the Apple case, isn't it? Because in Apple, the question is whether, even with a warrant, you should be able to open our cell phones, which contain all of the geolocational information about everywhere I've been for a month. So if you have access to my iPhone, it's just like putting a drone over me. You can reconstruct my movements for a month. Can that be obtained without a warrant or even with a warrant? Well, WWBD, what would Brandeis say? Well, first let's look at what Kerr and Friedman say, and they disagree. Kerr essentially says that you, in public places without physical trespass, don't have an expectation of privacy. He notes that the Supreme Court in the Jones case said you can't track someone with a GPS device, but that involved physical trespass of fixing the device to the bottom of his car, and here there's no physical trespass. Friedman disagrees and says because a drone search can reveal so much about us, the political rallies we attend, the people we associate with, our intimate hopes and our fears, channeling Brandeis in spirit, it should presumptively require a warrant. So we've looked at the history, the general warrants, we've looked at this debate among two scholars. Now let's look at what countries around the world say about this matter. And you can go back to the thrilling Interactive Constitution homepage and look at this final tool, Rights Around the World. You can click on any part of the Bill of Rights and see how other countries protect the prohibition against searches and seizures. So this is collection of evidence, which is our Fourth Amendment. Here it's quoted here. All these countries in yellow have versions of the American Fourth Amendment. So when we click on Japan, which has a Fourth Amendment, we see that General MacArthur, when he wrote the Japanese Constitution, cut and pasted the American Fourth Amendment. So the text is almost 53% identical. It's basically our version, word for word. By contrast, the Russian Fourth Amendment is a creepy prohibition against spouses not testifying against each other. Looks nothing like our beautiful Fourth Amendment and is on the Russian Fourth Amendment, I say. But fascinating comparison. And if you were to believe, and this is a very hotly contested point in constitutional law, that it's relevant to look at international practice in trying to discern the meaning of US constitutional provisions, Justice Stephen Breyer says yes. The late Justice Scalia emphatically said no. Then you might be interested in that global comparison. So here you just have a constitutional feast of resources to help channel Brandeis, the historical sources, the current debates, and the global comparison. If I'm going to try to do it like Karnak the Magnificent, or whoever that old Johnny Carson, guy was, it's obviously a hard question, but I think Brandeis would have said something like, this Apple search, which has the ability to reveal so much about us, which makes the general warrants and writs of assistance that sparked the American Revolution look like puny instruments of oppression, has the potential to reveal so much innocent information, even unrelated to that of the terrorist attack in San Bernardino, that it can't be justified even with a warrant, and that you'd need minimizing procedures that would limit the amount of information the police could seize and that would focus it on evidence relevant to the San Bernardino attack before you could even conceive of requiring Apple to turn it over. And then beyond that, whether the creation of a backdoor, which could be used and abused by what Brandeis called well-intentioned men, full of zeal but without understanding, I think is a hard question. Now that, I would call that a robust constitutional conclusion. No Supreme Court justice has taken the position that valid information cannot be seized even with a warrant, although they haven't confronted the backdoor question. But I want you to think creatively in the spirit of Brandeis in trying to take the values the framers were trying to achieve and channel it into a world they couldn't have understood. Now let's look briefly at the First Amendment. And I want to take up one question, which is very much before the world right now. And that is a new right recognized by the European Union called the right to be forgotten, which comes from the European Court of Human Rights. It's from the French droit à l'oubli, or the right of oblivion, which is extremely French. It's sort of right out of Sartre. All the French want to be forgotten and Americans want to be remembered. But what's also interesting about this new right to be forgotten, well, here's how it works. Basically, any data subject, that is anyone in Europe, can object to the publication of any truthful but embarrassing information about them. And then Google and Twitter and Yahoo, Google and Yahoo, Twitter is not a search engine. Google, Yahoo, and other search engines presumptively have to remove the data in question unless first a Google privacy lawyer backed up by a European privacy commissioner decides it's not relevant to public interest or to scientific, literary, or artistic discourse. And if Google guesses wrong and a privacy commissioner later second guesses the decision, then Google is liable for a fine of up to 2% of its annual income, which last year was more than $60 billion per incident. This fine, as you can imagine, concentrates the mind, and Google has removed more than 40% of the takedown requests it's received in Europe. Some of these have to do with the antics of public figures that would clearly be considered protected speech under the American First Amendment. So, for example, if during this talk one of you were to tweet that I'm giving a boring talk or the Interactive Constitution is overhyped, if I were in Europe, I could object that this scandalously offends my honor and demand that this outrageous tweet be removed, and then Google lawyers would have to decide whether I'm a public figure, whether your tweet is relevant to the public interest. And again, if they guess wrong, that's like millions of dollars for Google.
So when you say they guessed wrong, would they only be liable for damages if they improperly leave it up, or does it also count if they improperly take it down?
Good question. I don't know about the good faith efforts, but basically, if they take it down, I think they're okay. So they've got a presumption to take it down. But it's a good question because, you know, even if it's removed from Google, it still exists. This is the interesting part of the ruling. The case arose out of a guy in Spain.
Could you repeat the question?
Sure. The question was, and forgive me, when we do, let's get into questions actually, because this is the time for it. There's a mic that will travel around. So, or the government will just pick up our questions and broadcast them to everyone. The question was, does Google have to pay the fine if it wrongly takes it down or just if it leaves it up? And my instinct is, if it tries to take it down, it's okay. The fact that it remains accessible and not deleted from the internet is part of the original conception of the right, because the case Castella versus Spain arose from a guy who'd been convicted of bankruptcy in Spain years ago. And he says the fact that this article about his bankruptcy is still available on Google is irrelevant and outdated and should be removed from the Google search engine. Google fights it, they lose. And the Court of Human Rights says, yes, Google can't index it because it's very embarrassing to him, but it remains available on the Spanish newspaper that published it in the first place. So it's a kind of practical obscurity. But if you look hard, if you know about this case, and everyone now knows about the Castella case, which had the effect of calling even more attention to his bankruptcy than if he hadn't sued, which is known as the Barbara Streisand problem after one of her suits against the tabloids, which called even more attention to her. I think it was real estate shenanigans than would have been if she hadn't. The size of her house, yeah. There we go. See, we would not have known about the size of Barbara Streisand's house if she hadn't sued. All of this is the basis of the European right, which has to do with practical obscurity. So WWBD, the reason it's such an interesting question, the young Brandeis clearly would have favored the right to be forgotten, but I think the mature Brandeis would have repudiated it. The young Brandeis would have said this was precisely the kind of offense against honor that all citizens, including celebrities and public figures, should presumptively be allowed to remove. And he's scrambling around. He finds no root of this right against honor in US law. He looks to Roman law. So he proposes a whole new series of what are called Brandeis torts, which sound like a delicious dessert, but are actually an unsatisfying and confusing series of decisions. And the reason they're so unsatisfying and confusing is that both they require judges to decide who's a public figure and who isn't. In the age of the internet, all of us are 15-minute public figures. If the definition of a public figure is someone who thrusts themselves into the vortex of public debate, which is the language from the Supreme Court's Gertz case, now that we all are journalists and micro-celebrities with Wi-Fi and cell phones, we each have our 15 minutes of blogosphere fame. So that's the question, who's a public figure? And then what kind of discourse is relevant for public interest? Well, that's a decision the young Brandeis was willing to have juries and judges make, balancing what's necessary for the public interest between what kind of conduct is highly offensive to a reasonable person. These subjective judgments in an age of exposure, when almost everything except for celebrity sex videos has been deemed to be not highly offensive, is one that the mature Brandeis came to think, as the beautiful Whitney concurrence shows, that citizens should make for themselves. The best counsel for evil, the best response to evil counsels is good ones. He thought that it was wrong for authorities to decide what citizens should be interested in. As long as there was time enough for reasoned deliberations, then people should have the opportunity to strike that balance for themselves. And that's why, since the right to be forgotten clearly violates the mature Brandeis' notion that only speech that's intended to and likely to cause imminent violence can be censored, unless it's false or libelous, those categories he didn't call into question, he came to believe that truthful but embarrassing speech should be protected, even hateful speech, as long as there was an opportunity for deliberation. So that's my sense. Now, some disagree. My friends in the privacy community, like Mark Rotenberg at the Electronic Privacy Information Center, stresses the young Brandeis rather than the mature Brandeis, and thinks that maybe I'm stating the degree to which Brandeis changed his mind. I'm influenced by a very interesting new book by Neil Richards called Intellectual Privacy, which traces the evolution of Brandeis's views and says that Brandeis came to embrace this idea of freedom of thought or intellectual privacy that should trump the right of honor and dignity. So as usual, you can argue these questions round or flat, but I believe that it's one that Brandeis would have settled on the free speech side. Now let's have a question and answer about all of these matters. I can channel Brandeis on questions involving free speech, the curse of bigness, or privacy, or anything else you like. But what I want to leave you with is the inspiring counsel that Brandeis gives to each of us of the duty of self-education. For him, learning about the Constitution isn't a luxury or something that we can just do if it pleases us. He thought it was absolutely central to American democracy, that democracy would perish unless an alert, reasoning, self-interested citizenry educated ourselves about liberty and contributed to the constitutional conversation that defines it. And that's why I want to leave you with this inspiring counsel of Brandeis, who was such a Jeffersonian believer in the power of reason. He said, if we must govern by the light of reason, we must let our minds be bold. Thanks so much, and let's have a great discussion about WWBD.
Could you expand a little bit on how he defined bigness? I mean, what is a big company or a big institution?
So important. So he had some models of small-scale communities that he idealized. First, his father, who was a grain merchant in Louisville, Kentucky, where he grew up. Then the small-scale savings banks that he championed in Boston and he thought provided fair insurance as opposed to usurious companies that were cheating workers. Then companies like Filene's in Boston, where he was counsel to the situation, as he called it, a kind of Jeffersonian McKinsey consultant, where he's representing both workers and management to try to achieve common purposes. But his real definition of bigness, I think he would have supported caps on size of the kind proposed by Paul Volcker. It was a bill that died in the Senate that would have prohibited banks from risking more than 20% of their capital or something on proprietary trading. But his nemesis was J.P. Morgan, the oligarch who controls not only Morgan Bank, and interestingly, here at Brandeis and here at Dartmouth and the Rockefeller Center, Brandeis is far more opposed to Morgan than Rockefeller. He thinks Rockefeller is richer than Brandeis. And in fact, Rockefeller famously said of Brandeis, when he learned of how much he had when he died, it was just tens of millions, not as much as Rockefeller. Why, to think he wasn't even a rich man. But Brandeis believed that Rockefeller and Theodore Roosevelt had misunderstood the source of Brandeis's power, which wasn't the capital he personally possessed, but his control over the quick capital of others. This is Morgan's control that Brandeis opposes. So Morgan, by allowing the directors of Morgan Bank to be the directors of railroads, which he controls, and shipping companies, and purchasing companies, makes it possible to basically travel around the world, as Brandeis talked about it in Other People's Money, without leaving an instrumentality or company controlled in some sense by Morgan. And in this sense, how is it possible to get a fair deal when the same controller is on both sides of the deal? He's thinking that citizens, he didn't like the word consumers, are being recklessly played with by Morgan's control over their quick capital, and also by the risks that he took with their capital, which led to the crash of '29. Brandeis predicts the crash of '29 in 1927. He says, I don't understand why people don't go broke. He considers the stock market legalized gambling. He only invests in bonds himself, and he dies with $3 million, which is hundreds of millions of dollars in today's money, because he invests so conservatively and spends so little, only 10% of his income. The rest he gives to his pro bono activities and provides for his family. And in this sense, he does predict our current anxieties over the crash of 2007 and the derivatives, which are so unforgettably described in The Big Short, which is well worth seeing. All of those instruments whose values people couldn't understand because they're so complicated were versions of the kind of complicated and risky instruments that Brandeis objected to in the 20s. So that's a long way of saying that, like Jefferson, Brandeis was something of an agrarian romantic. I mean, his real ideal community is both the Periclean Athens, where he thinks citizens can deliberate face to face, not noting, by the way, citizens are men, and the society has slaves, and Jefferson has a terrible blind spot, and that is slavery. And Brandeis too is not a crusader for racial equality. He's not against it as Jefferson was, but he, unlike his championship for equal rights for women, he's sort of silent on racial issues. So this is a sort of blind spot for Brandeis. But one of his models is Periclean Athens, a slave society. The other is the kibbutzim of Palestine. And if writing other people's money and being the greatest prophet of free speech and privacy isn't enough, Brandeis also becomes the leader of the American Zionist movement in his 50s and is more responsible than anyone else for persuading Woodrow Wilson and the British government to recognize a Jewish government, a Jewish state in Palestine. It's an incredible story. He's not even an observant Jew. He's raised in a secular household. He has a Christmas tree. But he meets in his 50s a journalist who's Theodore Herzl's American secretary, Theodore Herzl, the founder of modern Zionism. And this guy, Jacob de Haas, says twice, Louis Dembitz was a noble Jew. Louis Dembitz is Brandeis's favorite uncle. He changes his middle name from Davids to Dembitz because he loves Louis Dembitz so much. Dembitz is the only Orthodox Jew Brandeis ever knew growing up, and he was a great Zionist. He's also one of the 3 Republican Southern delegates to the 1860 convention that nominates Lincoln. So that, combined with the fact that Brandeis is really impressed during a garment strike in 1910 with the intelligence of both the Jewish Eastern European garment workers and their employers. They're reading Tolstoy in their free time. They're very empathetic to each other's perspective. And he's so impressed by their intellectuality that and the reference to Dembitz convinces him to become the leader of the American Zionist movement. He takes to it with the same incredible organizational ability that he brought to everything they ever did. He makes the Zionist movement efficient on small scale. And then he goes to Palestine, and he's serenaded by a band that plays Hatikva, and he's just entranced. He thinks it's a miniature California, because here it's agrarian paradise where people are growing wild rice, and on these small-scale kibbutzim, or small-scale socialist communes, essentially, can achieve face-to-face deliberation. So whether this vision of small-scale deliberation has much to teach us, what it has to teach us in the age of the megabanks is disputed. Brandeis's critics say he was romantic. He didn't understand the economies of scale that could come from vertical integration. He was not sophisticated in the protectionism that he advocated for small businesses. He supported chain store laws that would have prohibited chain stores of his day from bankrupting small businesses. He would have supported the chain store laws today that still exist in Japan and Germany that Amazon and Walmart have struggled with. In Germany, Walmart is not allowed to occupy too much of the market because in Europe there's still protection both for small businesses and even small bookstores. So I think he would have been on the opposite side of the Justice Department in Apple's suit against the e-publishers who wanted to fix prices to keep up a certain amount of reward for authors. So in all of these senses, he's economically controversial, and your question is deep and deserves a lot of attention. But I think ultimately, for Brandeis, smallness was not just a notion of efficiency or consumer welfare. It was a constitutional principle of political economy. Like Jefferson, he said repeatedly, the framers of the Constitution sought not efficiency, but democracy. And he just thought in big organizations and big governments, people couldn't master the facts and achieve the self-government that was necessary for full participation. So he might have tolerated a degree of inefficiency in order to protect this value of political participation. Yes, sir.
How would Brandeis comment on the concept that money is speech?
Great question. We know that the excesses of corporations were his central crusade, and the progressive era laws that the Supreme Court struck down in Citizens United, including one from Montana, which the Montana Supreme Court upheld after Citizens United, and 4 justices said that they wanted to reconsider Citizens United of. These are all laws that he would have enthusiastically supported. They banned corporate and union contributions on the grounds that they were corrupting, and they defined corruption not in the narrow sense of quid pro quo corruption. If you vote my way, I'll give you money, but also the dependence of funders on their donors and the impossibility of attending to the public interest when you needed to raise money to support campaigns. So in his Citizens United dissent, Justice Stevens quotes Brandeis's very vigorous dissenting opinion in the Liggett case, which involved small business laws. And I just think there's, here it's such a good hard question, as all these are, because on the one hand you have this free speech libertarianism that says that you can only ban speech when it's intended to incite imminent violence, and on the other this anti-corporate crusading tradition dating back to Jackson, Jefferson, Brandeis, and Wilson, which says you can absolutely curb corporate power in order to protect political participation and political equality. So here I feel, like all of us, when you channel your hero, Brandeis would have agreed with me, But, and I think Citizens United is a hard question, actually. There are very strong civil libertarian liberals, like Nadine Strossen, the former head of the ACLU, and Floyd Abrams, the former lawyer in the New York Times v. Sullivan, who had a phenomenal debate at the National Constitution Center. Plug alert again, go online and see the videos of these incredible debates, co-sponsored sometimes with our friends at Intelligence Squared. Was Citizens United rightly decided? There you had these 2 civil libertarian liberals on the pro-Citizens United side, siding with the conservatives, and Zephyr Teachout and Burt Newborn on the anti-side. The audience votes before and after, and I guess it's a spoiler alert to say the anti-Citizens United side won there. But for Brandeis, I just think his strong opposition to corporate power was so intense that he would have been in dissent in Citizens United.
So back to the question of bigness, what would he have said, or what kind of, is there a role for big government in big global problems? I think, things like climate change, where you really need mass regulation.
He would have said no, and he was not a conventional progressive or a Hamiltonian on these questions. He voted to strike down the most centralizing aspects of the New Deal. There's this riveting story. Generally he believes in judicial deference to federal and state laws, and he dissents from some of the early decisions striking down aspects of the New Deal, but then he calls Tommy Corcoran, FDR's advisor, and Adolph Burl, an architect of the first New Deal, to his chambers, and says, you have to tell the president that this business of centralization has to end. We're going to end it. And they're terrified because he's like a prophet, and he's just stretching out his arms and he's jutting out his eyebrows and he's prophesying that centralization will destroy liberty. And then he makes good on his threat and actually votes unanimously with the entire court on what's called Black Monday to strike down the part of the New Deal he disliked the most, the National Industrial Recovery Act, as well as provisions involving the president's power to fire executive branch officials, and after that rebuke, the president has the court packing plan, and eventually there's the switch in time that saved 9, and then the second New Deal is more Brandeisian. So after the rebuke at the hands of the Supreme Court, the second New Deal, according to Arthur Schlesinger, was aflame with the spirit of Louis Brandeis and Wilson's New Freedom, the first New Deal with Theodore Roosevelt's New Nationalism. So the first New Dealers were more centralizing, and Tugwell and Burrell, the Columbia law professors, openly scorned Brandeis and said it's unrealistic in this age of the modern regulatory state to yearn for small units. But the second New Dealers are more Brandeisian. They passed things like the Robinson-Patman Act, and most significantly, the Glass-Steagall Act, which requires the separation of commercial and investment banking and does pretty well in maintaining financial stability for a generation until it's repealed during the Clinton administration, showing that bigness is an equal opportunity vice, that both Republicans and Democrats have tended to be more Hamiltonian than Jeffersonian. Aside from civil libertarian liberals and libertarian conservatives who are Brandeis's natural heir, today, I think you could say, I don't know what's mainstream anymore, but candidates, let's say the Republican front-runner as well as the Democratic front-runner, appear to be Hamiltonian in their view of federal power, not Jeffersonian, and I wouldn't expect them to be, and they've opposed breaking up the banks to the same degree. So this is another reason that modern progressives perhaps have not embraced Brandeis with fervor, because they believe that ours is essentially a Hamiltonian world, and this nostalgic and romantic attachment to the small shires of 5th century Athens, doesn't have much to teach us. But no, I don't think he would have wanted global bodies to address climate change, for better or for worse. He thought you should break up the banks so they were small enough to be regulated by the states. I'm just going to look for any new questions. One, please.
So I'm writing a senior thesis on hate speech, and
Yes.
I came here as a break from writing, and my thesis seems to have chased me here.
I'm so sorry to add to your reading list.
No, I'm happy to.
Good.
And so I have a question for you about the imminence test that may be very specific. So I'm totally happy if this isn't your area of expertise. But I wonder if Brandeis were alive today, after the civil rights movement and after desegregation, and I know he was fairly quiet on issues of race, how do you think he might react to some critiques of the imminence test that it should take into context racial history and the context in which someone speaks in uttering hate speech, of saying you can expect a certain amount of imminent violence, more so for hate speech than for something else?
So this is such an important question, and if you can solve it in your paper, you will have made a great contribution to discourse, because this is the central First Amendment question right now. How broadly should imminence be defined, and should it be viewed in the context that you've just described? Now, I've already said Brandeis was not a leader in matters of racial equality, so I'm not going to try to, well, in fact, I had the privilege of studying with David Reisman, who was one of Brandeis's last law clerks, and he said that Brandeis would not have been a fan of the VMI decision, which struck down all male military academies, because of his devotion to states' rights. So I think if you're going to ask narrowly what would Brandeis in his time have thought, probably states' rights would have trumped racial sensitivity, because it just was not his issue. He did, again, he was not a bigot. He advised Charles Hamilton Houston and the people who created Howard Law School, and the Brandeis Brief, which insisted on the importance of facts, so inspired Thurgood Marshall that he used it as a model when arguing Brown versus Board of Education. So this is not like Woodrow Wilson, who openly supported federal segregation. He just wasn't a leader on that question. So, but what does the Brandeis principle say about whether context should be taken into account and so forth? I think I'm trying to see if, I'm not sure I have other Whitney quotations right here, but he was really very specific about the idea of counter speech as the best remedy for hateful speech, and did address, I read those 2 paragraphs, and there's more in Whitney along these lines, but I think his whole notion of imminence was because of his tremendous faith in reason. And he really thought if there's time enough for reasoned deliberation, then there's no need to fear that unreasoning insults could lead people to wrongfully reach racist conclusions, because the best counsel for evil words as good ones. So I think with that Enlightenment faith in reason, I think that was why he defined imminence so incredibly strictly. And that it wasn't a coincidence that he's talking about violence having to result. Setting aside his own racial history, I don't think he would be moved by the notion that because a particular group has suffered special offense, it needs to have a more expansive conception of imminence, because he was such a person of the Enlightenment and really would have believed that all you have to do is deliberate and then the noxiousness and evil of bigotry could be avoided. I'd like to read Whitney more closely, and maybe it's worth your parsing it and reaching your own conclusions, but I think that really is Brandeis' central contribution to American jurisprudence. That's why, unlike the entire rest of the world, we don't ban hate speech because of that imminence test. It may be also interesting to look at the way, for your paper, the way the real deciders for free speech approach hate speech. It's not the Supreme Court, but it's lawyers at where? Who are the people who really control this?
Really
Control free speech. Like who decides whether hate speech can be?
The Supreme Court, really.
The Supreme Court can only decide whether government actors can speak. It's lawyers at Google and Facebook. It's their hate speech policies and whether they allow stuff on Facebook or blogs or Twitter to go up or come down that has more of an impact on who can speak and who can be heard than even any decision of the Supreme Court. So Facebook and Google have very interesting terms of service that don't exactly track the First Amendment, although they are more speech protective than Europe, where hate speech can be banned. So if we're in France or Germany, hate speech is illegal, Holocaust denial is illegal, it's not close, it comes down. And when they are in France and Germany, Google and Facebook have to obey by local laws, and Holocaust denial material will come down from google.france or google.germany. But when it comes to google.com or facebook.com, both companies have drawn a bunch of interesting distinctions. They've said, for example, that it's okay to criticize a religious leader, but not a religion. So you can say, I hate Muhammad, but you can't say, I hate Muslims. And that's why when they were asked to remove the Innocence of the Muslim video, which was this very clumsy and to Muslims offensive criticism of the Prophet Muhammad, both Google and Facebook left it up, even though President Obama said take it down, claimed it was causing the Benghazi riots. Later it appeared that it didn't cause the riots because it had been up in Arabic for months before. But they just applied their policy. They said they're criticizing the leader, not the religion. We're going to leave it up. Where did they get that distinction? It turns out it was made up initially by Facebook's then head of public policy, who's a recent Bowdoin grad who'd studied John Stuart Mill as an anthropology major at Bowdoin and was moved by this distinction and basically wrote it into the terms of service. And Google came to similar policies. It just shows how remarkable it is. If you want to understand how the Constitution operates today, you can't just look at Supreme Court opinions, but at how these great private companies are applying their terms of service. Back to Brandeis, what would Brandeis have thought of a world where lawyers at Google and Facebook have more power over who can speak and who can be heard than any king or president or Supreme Court justice? I think he would have been troubled by the degree to which corporate power can influence constitutional values. That was the central concern of his life. He was a free speech libertarian, so I'm not sure he would have supported laws to regulate Google like a public monopoly, but he might have. That would have been on the table, the idea that if Google is effectively functioning like a quasi-public monopoly, then it could be regulated or at least required to respect the First Amendment. A constitutional amendment to regulate Google in the same way that Jefferson proposed a constitutional amendment to regulate monopolies might have been something he was interested in. We're obviously channeling pretty freely here, but the effect of corporate power on free speech would have interested him. But back to the bottom line, I think he took imminence seriously and really would have meant it. If you can make a Brandeisian case, if you want to make a Brandeisian case for regulating hate speech, I would go back to his original privacy article. The 1890 article absolutely would have allowed for the regulation of hate speech, would have taken context into account, would have said, because really we're talking about here a clash between liberty and dignity, and people who in very good conscience think that speech that offends dignity should be restricted, even if it doesn't threaten to cause imminent violence, are invoking this distinguished tradition, which is rooted mostly in Europe and which Brandeis tried to import here and then backed away from. But you know, it's a very hard balance. So you can make a case Brandeis against himself, and you might well conclude that the early Brandeis should win and that hate speech should be regulated. Okay, and please send me a copy of your paper when you figure it out. Yes, sir, in the back.
What did Brandeis see as the priorities for the central government? If any.
You know, although he was cited sympathetically by Hayek, the libertarian hero, I don't think that he was a minimal watchman state libertarian. He obviously strongly supported progressive state regulations, including maximum hour and minimum wage laws. He believed strongly that regulations to ensure regularity of employment so that workers were not vulnerable to having their salaries susceptible to the vagaries of the production schedule were important. It's just that he wanted to pass these regulations at the state rather than the federal level. So he was not a interested, I mean, one of the, I hope, provocative arguments in these book is he was less of a conventional progressive than he's been painted. And in fact, his contemporary biographer, Alfred Leaf, said that he had disdain for the idea of rule by experts that would spare the people the need to rule by themselves. But at the same time, he enthusiastically both voted to uphold on the Supreme Court and defended as an advocate the need for health and safety and welfare regulations. The Brandeis brief defended maximum hours for women laws and had a flurry of international and other statistics showing that women in risky professions needed to have their hours capped. So I think it's a long way of saying that he was a moderate. He thought the role of state governments was to balance the interests of labor and capital fairly to ensure that both sides got fair return without usurious returns. He didn't like big unions or big government, but he did believe in unions as well as smaller businesses. And as long as it happened on the state level, he was perfectly comfortable with regulation. He just didn't like an overweening federal government or state. Thank you, sir.
Given Justice Brandeis's the importance he placed on education and enlightenment, how do you think he would view the affirmative action cases presently in education, going back to Bakke and since then?
You know, they're the hardest cases. We had a great discussion of them in class today, and the students made the good arguments on both sides. My question would be, what would his constitutional conclusions be, not his policy views? Did he think it's a good or bad idea? And the truth is that Brandeis never, like modern justices, didn't delve into the original understanding of the 14th Amendment. There's now a tremendous bit of scholarship about the original understanding, which suggests that the framers of the 14th Amendment intended to ensure colorblindness with respect to what they called civil rights, but not political or social rights. So they didn't think the 14th Amendment applied to voting rights at all. They would have thought that Bush v. Gore was inconsistent with original understanding. And their notion of civil rights probably did not include the right to go to public schools, because some people stood up in the Congress that decided, that passed the 14th Amendment and said, don't worry, South, this isn't going to require integrated public schools. That's a real problem for originalists, because it means that Brown versus Board of Education is very hard to reconcile on originalist grounds. And Justice Scalia never had a great response to that problem. I had the privilege of a dinner with him, which I wrote about recently, where I basically asked him point blank, hey, what about Brown and original understanding? And after going back and forth a bit, saying maybe the text or something, he kind of had a belly laugh and said, you know what, no theory is perfect. So he was kind of conceding that it's a bit of a lift for originalists. So Brandeis, I raise all that because Brandeis did care about text and paradigm cases and original understanding, as his invocation of the writs of assistance shows. He was, Jack Balkin has used the phrase living originalist. Others talk about new textualists or liberal originalists. There's a group of scholars, and judges who believe that you should look closely at the text and original understanding of the 14th Amendment, which can sometimes lead to progressive as well as conservative results. So a living originalist might say, if I'm channeling Brandeis in that way, I'm just arguing this round and flat, might say that even though education was not a civil right in 1866, it was certainly by 1875 when they passed the Civil Rights Act of 1875, and by 1954 when Brown was decided, education was so broadly provided by the state that it was considered a civil right. What's turns on that? Well, you could say if it's a civil right, you have to be colorblind, the anti-affirmative action side, or you could say the framers of the 14th are centrally concerned with prohibiting caste-affirming laws, laws that stigmatize and degrade and mark African Americans in particular as less worthy than as inferior to white people. And they endorsed affirmative action programs like the Freedmen's Bureau, whose benefits went far disproportionately to African Americans than whites, and therefore they did not believe that the state had to be colorblind against the range of state action, but only with regard to state action that was caste affirming. So I don't mean to be maddeningly nonpartisan in channeling the arguments on both sides, but I think if you're going to be a living originalist, it's very hard for a strict originalist to argue against affirmative action. And Richard Epstein, the libertarian scholar, has basically he's conceded that it's, for him, private universities should be able to do what they want because they're not bound by the 14th Amendment. And as for public universities, he's not an originalist, so I think he does like colorblindness. But if you're just going to ask what the 1866 people thought, then public universities should be free to discriminate against or in favor of people as they please, to prefer or to exclude minorities. Once you view education as a civil right, it gets more complicated. I know that was deeply unsatisfying, but what I want to convey is that this is a hard constitutional question that can't be easily answered by simply saying the framers clearly thought this or clearly thought that, because they were living in a world where the state didn't provide education on a broad scale.
There's a university well regarded in Massachusetts that invited and then uninvited a prominent critic of Muslim religion, Ian Hersey Ali, and I was wondering how Justice Brandeis would comment on the conduct of his named university.
His alma mater. Gosh, in his day, it was Sacco and Vanzetti. There was a Jewish quota, of course, at Harvard in those days. And Abbott Lawrence Lowell, who was the president of Harvard, was a fierce opponent of Justice Brandeis in terms that have an anti-Semitic cast today when you read the confirmation hearings. And in the old New Republic, where I had the great privilege of working before it unfortunately blew up a year ago because of bad management, there hung a chart that the editors had prepared for publication in the magazine showing the interlocking web of influence opposed to Brandeis's confirmation. And at the hub of it was Abbott Lawrence Lowell and State Street bankers and then J.P. Morgan, and it showed how all of these characters were interconnected. The punchline of the story was the chart never appeared in the magazine because the publisher, Willard Straight, married to Dorothy Straight, had himself worked for J.P. Morgan in China. So he killed the chart because he didn't want criticism of Morgan. So I'm working my way around this important question. So Lowell both has a Jewish quota at the college, opposes Brandeis in these certainly he doesn't like his economics, but he may not like his religion either, in the genteel anti-Semitism of the day. He also, Abbott Lawrence Lowell, presides over the commission that sentences Sacco and Vanzetti, the Italian anarchists, to death, despite strong doubts about their innocence. And Felix Frankfurter, then in his great civil libertarian phase, writes these anguished editorials saying that Lowell couldn't believe that two Italians could be right and the Brahmin aristocracy could be wrong. I think, unless I've got my chronology wrong, that Brandeis is on the court by that point, but I'm sure he's on the Sacco and Vanzetti side and shares Frankfurter's scruples. So he doesn't like anti-Semitism, and he is in favor of these dispossessed minorities. And I'm, just channeling him on no platform policies. I was not a fan of the view that people should be denied the right to speak because they violate dignitary rights. I mean, Ayaan Hirsi Ali, in addition to her very controversial and to some offensive comments about Muslims, also has made those comments in the context of defending a Brandeisian conception of the First Amendment that really insisted on, said that those values were being threatened in Europe. So for all those reasons, it depends if you're convinced by which way you channel him on hate speech. But if you agree that he would have supported the expression of hate speech, then he would have admired rather than repudiated Hirsi Ali's First Amendment vision and wanted her to speak. You're asking really easy questions. Yes.
Three sort of interrelated questions. First, can you tell us a little bit more about Jefferson's proposed constitutional amendment to ban monopolies? Second, did Brandeis ever write about or speak about large corporations in the context of their potentially becoming alternative states, in other words, corporation states as opposed to a nation state? And third, did he ever write anything about Article 4, Section 4, Clause 1 of the Constitution, which is the one that says that Congress shall guarantee to every state a Republican form of government?
What great questions. I know I don't want to delay you too long, so let me answer them and then we can maybe wrap up. Here's Jefferson on monopolies. The Boston Tea Party, Brandeis, like Jefferson, is a foe not of capitalism but monopoly. I'm reading from my riveting introduction to the book, which takes up this question. He objected to economic privileges created by law, not to free markets. In his hatred of monopolies, Jefferson was not alone among the American founders. The Boston Tea Party, which sparked the American Revolution, was a rebellion against the government-granted monopoly held by the East India Company. After the Constitutional Convention, Jefferson complained to James Madison that the Constitution contained no Bill of Rights protecting, among other basic liberties, quote, restrictions against monopolies. And Jefferson supported the following constitutional amendment, quote, monopolies may be allowed to persons for their own productions in literature and their own inventions in the arts for a term not exceeding a certain number of years, but for no longer term and for no longer purpose. So that's the Jeffersonian anti-monopoly amendment, and it doesn't go through. You can, I should say just because it's so cool, look at the other amendments that were not adopted, that were proposed by the Senate. That one wasn't, but not adopted. And they include Madison's proposal, which he considered the most important in the bunch, that would have prohibited the states as well as the federal government from violating the rights of conscience, freedom of the press, or trial by jury in criminal cases. It's the interactive Constitution. You can explore some of that. So that's the anti-monopoly amendment. Did Brandeis talk about corporations as quasi-states? Well, I think when he was, I don't think he used that term, but when has this amazing passage in Other People's Money describing how J.P. Morgan's deputies can literally travel across the globe without leaving industries or instruments controlled by Morgan, he's absolutely making the case that they exercise the power of governments and insists on applying constitutional principles to them, even though they're not formally bound by the Constitution. And in that sense, I think would have been sympathetic to that critique. And what was the last question again? Was
Article 4, Section 4.
The Republican form of government clause is just a very important clause. He did not, to my knowledge, write about it, although Luther and Borden, the big Republican form of government case, let's see when it was decided. Isn't Google wonderful? That's the definitive case talking about 1849. He would have known it, but not written it. And there was there was a case, he may have decided a Republican form of government case as well. And I will, rather than continuing to Google in public, I'll email you the citation. But the principle behind the Republican form of government clause was central to the Jeffersonian concern about aristocracy. It's trying to prevent an aristocratic caste system from being reintroduced in America. Obviously, a monarch is the quintessential example. But there were arguments during the Civil War period, which Brandeis did study a bit, that vast malapportionment, which allowed minorities in rotten, malapportioned boroughs to select a majority of delegates, violated the Republican form of government clause. And I think Brandeis would have been sympathetic to that kind of arguments because he's so concerned about economic royalists, as Jackson called them, or oligarchs, or and so forth. So we'll revisit on the Republican form of government case that he talked about, but that central concern is the right note to end. What a glorious time it was in American history when you could have one of the most influential justices of his time speaking openly about our financial oligarchy, denouncing the risks that financiers take with other people's money, talking about the constitutional necessity of taming bigness in order to ensure economic justice, but at the same time deeply respecting constitutional limitations to ensure that the big government, like big corporations, did not threaten liberty. This inspiring figure, so unifying for our age, needs to be heard and needs to be resurrected. And let's end with those beautiful words. Well, I'll give you another Brandeis quote to end with. We need to educate ourselves about the Constitution. We have to convince our fellow citizens about the importance of constitutional self-education, because without education, liberty will flourish. It will be determined by what Brandeis called men of zeal, well-intentioned, but without understanding. Thank you so much for a wonderful visit.